Because
I'm
something's
sorry.
wrong with you. You have
You
a
said
mental
what?
problem. You have a mental problem.
I
If
have
you
a
think
mental
the
problem.
laws in the
How?
United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world, there's clearly something wrong with you.
No, what did I make up?
All of it. Good morning. The 14B District Court is now in session. My name is Elaine Washington. And
I find everyone's pain funny but my own. I'm French.
Mr. Fantera, if you, the court will call the case of the Ranches of Rosebrook versus Anais Battle, case number 25C-1245.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Battle, please unmute and state your name.
Anais Battle, appearance especially, not generally.
Thank you. All right, we're here for the continuation of the hearing today.
Buckle up, guys. Today we're diving into a case that's equal parts shocking and frustrating. A man named Brett walks into court facing serious accusations, from assaulting two officers to allegedly attacking his ex-girlfriend. What's wild here isn't just his charges, but how far his attorney seems willing to go to keep him free. Judge Simpson now faces a question. Can justice afford patience with someone as volatile?
I believe that we're in the middle of your, well, actually it was Ms. Battle's direct.
Yeah, I think Ms. Battle was cross-examining Ms. Charles.
That's correct. Ms. Battle, are you ready to proceed?
Yes. So, Don, do you have a signed lease between me and you in this case?
Yes.
Did I ever waive my rights or agree to the terms in writing?
What's the question?
Did I ever waive any of my rights or agree to your terms in writing?
Your Honor, I object. I have no idea what that means.
Meaning that there are waivers inside of the lease.
Your Honor, she's got a signed lease. That lease was, we moved to have that admitted last time, and it was admitted. Ms. Battle did not object. So I don't know what she's asking right now when she talks about a waiver. She signed the lease.
Okay, that's fine. Are you aware of the notice of rescission that was sent?
Yes.
Your Honor, I object. Rescission, we can't go down this road again.
Why are we not going down the road?
Let him finish his objection, please.
Okay.
Your Honor, this case is not about rescission. It's about, this is a non-payment of rent pay and stay case. The question is, how much money does she owe in order to stay in her lease? She believes, and she stated, and she was overruled by Judge Vandenberg, and I believe by you, that her belief that she rescinded her lease and therefore she gets to stay until she finds a new place is not the law, and she should not be allowed to pursue that line of questioning. This is not about rescission, which, by the way, she hasn't done anyway.
All right. So your argument is that her question is not a legal question and therefore you object.
It's not based upon law.
It is based upon, what law is it not based upon? It's based upon common law. You have not proven or stated any laws or facts that back what you're saying. Unlike me, I have.
The defense jumped straight into denial mode, twisting the story like reality's optional. She claims Brett only punched one officer and then suddenly became cooperative, a story that collapses under the weight of police reports and eyewitness accounts. The prosecutor calmly exposes every inconsistency, and Judge Simpson's expression says it all. Disbelief mixed with restrained irritation. The truth is hanging in the balance.
Okay. Did you write me a notice to quit filing this action?
A notice to quit?
Yes.
No.
I think she's referring to a demand for possession,
A
Dawn.
demand for possession? Yes.
No. A notice to quit.
No.
Right. Do you have proof of delivery or service of any notice to quit?
No, I didn't send one.
Right. Are you aware that MCL 657-16 requires a notice to quit before initiating an eviction?
Your Honor, I object. Miss Ms. Battle is confusing the term notice to quit with demand for possession. A notice to quit is how you start a termination of tenancy case. This case was started with a demand for possession. If Ms. Battle wants to use the wrong term, she's going to get the wrong answer. The statute says that we can start a non-payment of rent case with a demand for possession, and that was issued. And if she asked that question, Ms. Charles can answer that question.
Is there proof of service? Is there a proof of delivery on that demand for possession?
Miss Battle, can you do me a favor, please, ma'am?
Yeah.
Give me one moment. You studied a statute that I actually need to look up. MCL what?
I'm sorry?
What was the statute that you cited?
MCL 657.6. I mean, not 57.6, 600.5716.
Yeah, have you read that statute?
Yes, I had read it when I first did this.
It uses the term demand for possession.
Okay, everybody please stop typing. It says a demand for possession or payment.
As the evidence unfolds, the gap between the two sides widens. The state details how Brett punched two officers and twisted one's finger so badly it caused injury. The defense clings to technicalities, but it's a losing battle. You can feel the courtroom's patience draining fast. It's no longer about guilt. It's about credibility. Judge Simpson listens, but every word seems to chip away at the defense's story.
Is there a proof of service of it on the record?
That's a different question, though. So, okay, go ahead.
But that's the question I asked next. Once he said that the
But I
demand for
wanted to
possession.
clarify your question before.
I appreciate it.
All right, Ms. Charles, please add her question next. Is there proof?
Do you have a proof of delivery or service for that demand for possession?
Nope.
Nope. Did you know that under MCL that you're required to have a certificate of service or proof of service on the record?
Your Honor, I object. She's not using the statute changed 10 years ago so that you now need on a demand for possession a certificate of service. And that's what's at the bottom of the page. If she's looking for a proof of service, meaning somebody going to the door, she's going to get the wrong answer again. The term is certificate of service, and I believe Ms. Charles will answer that question differently because there is a certificate of service at the bottom of the demand. So I would appreciate if she's going to cite statutes, she cites them correctly.
Okay. That's fine. I didn't cite an exact statute, but I appreciate your objection.
What was the statute that you cited?
MCL 657.6. I mean, not 57.6, 600.5716. I just said MCL because they're both under MCLs. Both proof of service and certificate of service are both under MCL.
No.
All right, everybody.
You
so let's not make my ruling.
Let's just okay. All I'm trying to do is ask questions to make sure certain things are on the record. A certificate of service is not on the disposition, and just like she read on 600.
By now, the defense is visibly struggling. Their story doesn't align with the evidence, and their tone shifts from confident to defensive. The judge presses for clarity, asking questions the attorney can't cleanly answer. This is where courtroom skill meets hard truth, and the defense is clearly outmatched. Brett's image as a misunderstood kid starts to crumble as his violence becomes undeniable.
5716, was the property described on that dispossession?
Yeah.
Was there a description of the property?
Yes.
If there was a description of the property?
Correct.
On my copy, there is no description of the property. But let's continue. Does your company participate in HUD programs or accept federal HUD assistance?
Yes.
Okay. Did you provide me with grievance procedures required by HUD?
Did I provide you with what?
Grievance procedures required by HUD.
Your Honor, I object. That's irrelevant. There are no such grievance procedures under this anything that I'm aware of. I mean, I don't even know what she has a grievance about.
Right. The grievance would be with the breach, and you all have a grievance, and hence on why you initiated a hearing for the breach of the contract. So it goes back to HUD because you're publicly funded, right?
No, we're not.
No, we're not publicly.
Well, you accept HUD housing. You accept HUD housing, and you apply, and you are in compliance with HUD laws and policies, correct?
Yes.
Right. Okay. So if you have HUD terms and you're
Your Honor, I object. Miss Battle is taking.
Object to what? I didn't say anything yet.
Well, I'm objecting because she asked Miss Charles a question, which was, do you get any funding from HUD? Yeah, most companies do. We do. And then she takes that and starts taking that to a next question where it says, well, when you get funding from HUD, and then she's assuming.
I didn't assume anything. I asked the question.
Okay, what was the question you were going to ask?
I said, do you have to follow HUD's policies? That was my next question.
And she said yes.
Right. And then you objected after that.
No, and then you started the next question.
No, I started the question, but I didn't get it out my mouth before you objected me.
Let her ask the next question, and if you have an objection, I can hear it after she finishes her question.
Okay.
Things escalate when the state highlights the reckless nature of Brett's behavior, not just against the officers, but his ex-girlfriend too. The defense attempts to humanize him, but the prosecutor fires back, reminding everyone this isn't a one-off mistake. It's a pattern. The tension is thick now. The courtroom isn't buying the young and foolish narrative anymore. The reality of his aggression is undeniable.
You all have not been acting in honor and with good faith. So I don't know. I'm stuck on what to do. The integrity of the court is questioned.
With you. I don't know what that is, but you should seek some mental help. Because something's wrong with you. You have a mental problem.
I have a mental problem. How?
The United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world. There's clearly something wrong with you.
No, what did I make up?
All of it.
What? Be specific. No, be specific, because now you're lying on the record. This is perjury. I didn't make nothing up. 42 USC definitely applies to this case.
All right.
Jurisdiction is a threshold.
Ma'am, if you don't stop, I'm going to remove you from the court proceeding. So, Mr. Fantera, apparently we're not going to have a reasonable hearing here today because Ms. Battle feels as though the laws are very different for her as opposed to everybody else in the world. I'm not certain how to handle this going forward. You have submitted your documentation and she wants to argue stuff that's not law, regardless of my rulings. So therefore, I'm not sure what to do with respect to your case.
I would ask for a directed verdict. She hasn't said anything that is a defense to my action.
This is the moment everyone remembers. Judge Simpson's patience finally runs out. Her tone cuts through the defense's spin like a blade, calling out the nonsense directly. She even hints that Brett may need professional help, not excuses. You can sense the authority in the room shift completely. From this point on, it's not about argument. It's about accountability. The courtroom atmosphere changes instantly.
Rent owing in the amount of $3,432.42, court costs of $177 for a total of $3609.42. We would ask for a judgment for possession with a writ after 10 days, and she can avail herself of whatever procedures she can in another court.
So you're saying that none of my objections is valid towards your claim. So having a valid contract is not an objection. Oh, because you're saying that because a notice was given and unrebutted, it's not of law. That's what you're saying, right?
Yes, that's not the law.
It is. It's the law. It's Wells versus Zendaya of Michigan. It is.
All right.
It's
Um,
backed in case law, and y'all keep muting
ma'am,
me. It's okay, because he can talk, but I can't talk.
ma'am, you've argued that over and over, and I've ruled that it's not. You can file your appeals, file all the things you're filing, but when you file false liens against people, that is a crime.
It's not a false lien. You got defaulted on a private side, and you know that.
Okay, whatever. All right,
Yeah,
so
okay.
what I'm going to do is grant your judgment in this particular case because I've given her an opportunity to present defenses that are real, and she has refused to do that.
I didn't refuse to repent defenses. You didn't ask me about my piece of the case. I only got to cross-examine. You didn't ask me about my defenses.
What are your defenses, ma'am? And rescission is not one. I've ruled that it's not.
I'm sorry?
I know you heard me.
No, I didn't. You said, what are your defenses? And I didn't hear the last
That
piece.
your rescission is not a defense.
Okay, that's fine.
That is your defense.
Right, because, threshold matters are not an issue. But again, like I said, the fundamental objections.
The prosecution makes its final push, requesting judgment. With a firm tone, Judge Simpson grants possession and rules decisively against Brett. No hesitation, no sympathy, just law and order. It's a textbook example of a judge drawing a hard line when excuses run out. The defense has nothing left to say, and Brett's fate is sealed. Justice finally finds its voice in this courtroom. As the hearing wraps up, the fallout begins. Brett's federal filings and potential criminal exposure are revealed, signaling that this courtroom drama might only be the beginning. What started as a plea for leniency now looks like a prelude to deeper legal trouble. If this case proves anything, it's that the truth always catches up. Thanks for watching. Don't forget to like this video, subscribe to the channel, and we'll see you in the next one.